Greetings again to everybody. The advisory group of experts has convened today to conduct the interview with a candidate for the position of a judge of the Constitutional Court of Ukraine, Madam Tamara Novikova, who has been admitted to the competitive selection under the quota of the President of Ukraine. Madam Novikova is a judge of the Cherkasy District Administrative Court, and we are ready to begin with the interview with you, Madam Novikova. That is why I will first pass the floor to the Secretary General of the Advisory Group of Experts, Mr. Jaroslav Romaniuk, who will explain you today the algorithm of this interview, and who will further moderate it if necessary. So, Jaroslav, please.
Thank you, dear Mr. Chair. A good day to everyone, to all those who are watching our broadcast, and greetings with the Day of the Statehood. As the chairman of the advisory group has mentioned, all 6 members of the advisory group of experts are present at the interview, and the chairman of the advisory group of experts, Alex Zaller, members of the advisory group of experts, Ms. Maureen O'Connor, Ms. Hanna Sukotska, Oksana Vasilchenko, also member of the advisory group of experts, Vasil Shakun, and myself, the secretary of the advisory group of experts, Jaroslav Romaniuk. Nice to meet you. And also, we have the deputy members of the advisory group of experts present, Mr. Richard Barrett, Marek Zubik, Volodymyr Kuzmenko, Vitaly Makinchuk, and also distantly present Thomas Griffith. Nice to meet you. Tamara Vadimivna. I will briefly explain the regulatory framework and the procedure for conducting the interview with you as the candidate for the position of the judge to the Constitutional Court of Ukraine. So the interview is one of the mandatory stages in assessing the criterion of high moral qualities of the candidates. The advisory group of experts conducts interviews with candidates in accordance with Article 7 of the methodology, particularly for the purpose of clarifying and dispelling any doubts regarding their high moral qualities. So this is in your interest. We are giving you the chance to convince us to dispel any doubts, by the way, that group of experts may have as in part of your moral qualities. During the review of materials about the candidate Novikova, the AGE sent you questions for written explanations, and you, Tamara, you had the opportunity to prepare and provide answers, and we are grateful for the communication with the AGE. In this context, I would like to draw your attention to the fact that according to Part 8 of Article 7 of the methodology, you, Tamara, cannot provide information, documents, or other materials during the interview. Now, if the advisory group has requested the provision earlier, and you did not provide them with the specified period, or if you could have provided them on your own initiative earlier, but somehow you didn't. However, the advisory group may make an exception if we conclude that such an exception is justified. I would also like to inform you that the interview is being recorded and broadcast live on the AGE resources and on the Constitutional Court of Ukraine's website. Therefore, I would like to draw the attention of the members of the AGE and you, Tamara, regarding the restriction of the use of sensitive data and information with limited access to live broadcasts. If there is such a need, we will stop the broadcast live, and we will communicate here so that this information is not disclosed. Tamara Vadimivna, I would also like to draw your attention that the interview will last approximately 1 hour, and you will have the opportunity to answer questions with a time limit up to 3 minutes per question. At the end of the interview, you will have the opportunity to make a brief closing statement lasting up to 5 minutes. Some of the members of the advisory group of experts are English speaking, so they do not speak state language. There is a headset next to you. The color blue means that the simultaneous interpretation is ongoing from English to Ukrainian language and vice versa. If your level of English is insufficient, so please use the headset in order to be able to understand the questions that are posed and to be able to answer them. Thank you.
And now we are ready to start our interview with you, Ms. Tamara. And I'm passing the floor to the co-rapporteurs with respect to your candidacy. Please, dear members.
I would make a first question to you. A question concerning your professional activity as a judge. In 2007, you were appointed as a judge of the Cherkasy District Administrative Court for a term of 5 years. And then by presidential decree, you were dismissed from the position due to the expiration of the term. The basis for this decree was the decision of the High Qualification Commission of Judges of Ukraine and the decision of the High Council of Justice dated December 18, 2012, which denied recommending you for permanent appointment to the position of a judge of the Cherkasy District Administrative Court. You appealed this decision of the High Council of Justice to the High Administrative Court of Ukraine, and by presidential decree, the provision of the presidential decree regarding your dismissal was cancelled. Do you confirm this information?
Yes, thank you for your question. The question is quite, this issue is quite long. It has been lasting for a long period of time. So it was the subject matter of consideration of courts several times, and it has been considered by the High Qualification Commission and the High Council of Justice. It has been not been resolved so far. The matter is that nowadays I'm the judge, but without authorities. Without authorities, I've been because as of 2012 I was denied in extension of my authorities due to the previous law, which was valid as of the moment when my authorities expired. Nowadays there is no provision like that. Judges who are appointed to the position of the judge, they are appointed to the position of the judge without the specific term, so they are appointed indefinitely. And my situation has not been resolved. It's being resolved nowadays through qualification evaluation. Because all qualification evaluations for extension of authorities of the judges happened in 2016-2018, and they had their own peculiarities, which again continue. The situation is the same. So I believe that it is too premature to conclude whether this my qualification is confirmed or not, because this is the subject matter of consideration by the High Council of Justice. The High Council of Justice denied to the HQCJ regarding my dismissal in 2020 because the decision was not justified and there were no grounds to dismiss me based on the results of the qualification evaluation because I passed it. And the only thing that I did not get enough votes during the interview. That was the only instance. But that interview was the subject matter of consideration in the court because members of the HQCJ exceeded their authorities and interfered with my private life. So I challenged their decision. I have the right to do that as the individual and not only as the judge. So I believe that that was a violation. Nowadays, this issue is still open, and I believe that just like any other citizen, I have the right to realize my rights, both at the position of the judge and with respect to participation in the competitions. In the opinion of the AGE members, that can be your personal opinion. I really respect your opinion. I'm really grateful for being invited here. I'm really grateful for you to listen into my opinion. I'm grateful that you've studied my situation, that you've dedicated your time and efforts to our communication. So I'm really grateful. And I hope for objectivity and for high professionalism regarding study of this issue. Thank you.
Thank you for your explanation, but we have several decisions here, because you were in 2012, as we said, and it was the first question, you were denied a recommendation for permanent appointment. Then in 2016, by decision of the High Qualification Commission, you were found to have not confirmed your ability to administer justice in the Cherkasy District Administrative Court. It was the reason to have not ability to administer justice. Then in 2018, by decision of the High Qualification Commission, you were again found to have not confirmed your ability to administer justice. So it was twice, 2016 and 2018. Mm-hmm. And that in both cases, the High Qualification Commission of Judges found that you did not meet the criteria of professional ethics and integrity. And it is interesting, important for us, what was this lack of integrity, criteria of professional ethics and integrity? Did you appeal the decision of the High Qualification Commission of Judges? How was your argumentation? Because it is a very strong decision, very strong administration. Now, especially when you are running for the post of judge to the Constitutional Court.
Yes, thank you so much for your question. That is a very comprehensive question. This question was not even asked by the HQCJ, and it gives me hope that the advisory group of experts, after all, studies all the issues, all the risks, and all the strengths of all the candidates. With respect to the qualification evaluation that I passed and denial in continuation of the authorities of the judge as of 2012, I would like to point out that I was dismissed because of the expiration of my authorities as a judge, not because of some disciplinary sanctions or some other issues, but only due to expiration of my authorities as the judge. Why? Because back then I had a conflict with the president of the court. It is a well-known fact, who submitted inaccurate information about the quality of my consideration of cases. And that was a ground for me to not get enough votes during the meeting of the HQCJ when they were voting for my extension of authorities. I challenged this decision with the Higher Administrative Court. And on June 6th of 2013, due to expiration after I was dismissed, only then they took the decision, even though it should have been considered within 1 month. But since the political situation back then was the following, that I was dismissed from the position of the judge by Viktor Yanukovych, who back then was subject to events of the Revolution of Dignity. And I was the judge, I was an honest judge. I did not have any compromise. My parents have always taught me to be honest with myself and the law, and I've never made any compromise with my conscience. And I've never violated this law. But back then, let's say some officials found this situation not in their favor, so they decided not to recommend me for the position of the judge. Why did it happen like that? I provided that in my explanations in more detail. This situation has been explained. The quality of my consideration of cases was the highest in the court, and I've provided the note on the quality of consideration of my cases that I had over 200% as compared to other judges of our court as of 2018, but it was not enough because they had to deny in the submission to me because judges like me are not needed in the system. And back then there were no bodies like the AGE. I cannot say that back then that there were more confident and more independent officials who were responsible for evaluation of judges and who were providing recommendation to judges regarding their indefinite appointment to the position of the judge. So it resulted in the conflict which I've described in detail in my explanations as of June 21 of 2024. There you can find all the description in detail. So it became a ground for the lack of my recommendation. That was not the problem with the quality of my consideration or something like that. I had the highest workload in the court. If you look attentively at the schedule, there were judges who had 6, 8, 10 cases, and I had up to 1,000 cases. And I repeatedly addressed the president of the court that it was not fair and that it was not correct and that it was a violation of the principle of equality in terms of distribution of cases, but I was not heard. So I'm sorry, but this situation was marked and became a ground why I was not recommended for the position of the judge indefinitely in 2020. In 2012, sorry.
Of course, we can accept your response, but you know, it happened 3 times, yes, because it was in 2012, and then we see that in 2016, 2018, and it was always said that you don't meet the criteria of professional ethics and you are unable to administer justice. And you said that judges as me are not needed in the system. What do you mean by such a saying? Judges as me. What kind of I don't know characteristics you have, and why the decision has been done 3 times? Yes, to refuse you to be a judge.
Дякую.
Thank you. The matter is that I meant that independent judges who take decisions independently from interferences with their activities. Since Mr. Kovalenko, who back then was the president of the court and now he is a retired judge, quite often used this practice of interfering with administration of justice. So I had to put an end to such situations because justice should be administered independently in courts. Of course, he didn't like that, and he did everything possible for not recommending me. He submitted complaints to the HQCJ, to the HCJ, so that this procedure would work against me. With respect, after dismissal, what he managed to do in 2013, after all, I was renewed at the position of the judge thanks to the court decision when I won the case on June 6 of 2013. And when Yanukovych, back then the president of Ukraine, dismissed me from the position of the judge, I was waiting for changes in the procedure of appointment of judges for this position. I had to wait for a year for this procedure to be changed. And once changes were implemented, once the law was amended, it was necessary to undergo qualification evaluation. Back then, in 2012, this qualification evaluation was not required. In 2016, a quite interesting question that you've asked about 2016. I came to, on July 6th of 2015, I was renewed at at the position. On June 5, I was renewed at the position of the judge, and in July of 2016, I submitted an application to the High Qualification Commission of Judges regarding extension of authorities of the judge by means of undergoing qualification evaluation, because back then amendments to the law were introduced. According to the old procedure of qualification evaluation, exams should have been appointed, and qualification evaluation was not appointed for 6 months. So my qualification evaluation was appointed only in 2016, so I had to wait for a year again. With respect to your question, dear members of the advisory group of experts, in the conclusion, in the decision, it was stated that Judge Novikova complies with the criteria regarding anti-corruption regulations. And in 2018, during the same period of time, there emerged the conclusion that Judge Novikova had concerns regarding corruption. And corruption concerns, I don't even know where they came from, because it was the same period of time. And different decisions of the HQCJ, and these different decisions of the HQCJ interfered with extension of my authorities of the judge indefinitely. These decisions are still valid. They have not been cancelled. So I intend to pass all the procedures, to undergo training, to pass qualification evaluation, all the procedures set out by the law in competitive procedures in order to be renewed at the position of the judge. Even if not in Cherkasy court, I asked about any court, and I was denied, because again, I see corruption here, because I was sent back to Cherkasy District Administrative Court. Ukraine has so many vacant positions of judges after their retirement, and I asked Holodnyuk, the head of the SGA, please appoint me in order to avoid the conflict, in order to avoid any misunderstanding, give me any court. It did not matter for me. No, they sent me back to Cherkasy court, and I continued fighting, and I continued involving into this survival, because that's survival of the judge in this situation. I'm sorry, but thank you for listening to my opinion. Tamara, as far as I understand, your desire to work in Cherkasy court was related to the situation that in 2017 in Cherkasy you bought the apartment, right, where you reside. Can you please tell us, taking into account that you related your professional activities with Cherkasy, but the apartment was bought in your mother's name, what was the reason for that? First of all, thank you for this question. It's a very appropriate question, and this question has been asked several times, and I've provided answers in writing several times. And I would like to explain in order to refute any doubts that the advisory group of experts might have regarding property. The situation is that I did not have where to live. The court did not provide me with accommodation for 5 years. So when I moved from Kiev region back then to Cherkasy, back then I was registered in Jabani and then later on in Kiev. All the time I was in very poor accommodation locations, roughly speaking. So my mom told me, we will do everything possible. I understand that it is your endless fight, and so that you would not be, the judge should live separately, you know, because the impact of the society is so high in our situation. Even nowadays, when there are so, issues related to the purification of power. No, my question was why the right of ownership was registered in your mother's name, even though the apartment was for you. Yes, I don't deny, but I did not have this funds to buy this apartment and just tell my mom, give me money. That's not appropriate to use my mother's money for myself. It's like, I don't know, I cannot do that. If I have money, then I can buy whatever I want to buy, but my mother's funds are my mother's funds. That is her apartment, that is her opinion. I only participated in the situation when I had salary, and this salary of the judge was invested somehow in order to repay that, because I did not have this opportunity. I described the situation about the source of origin of funds. Tamara, thank you. Let's move on to the next question. So, actually, the apartment cost 466,320 hryvnias, slightly more than a half. These were your mother's savings, and you've explained that some of these funds were your savings. And again, the question is that actually you bought the apartment using your joint funds, including your mother's funds and your funds, and taking into account the situation that the apartment was bought for you, right? But it was registered in the mother's name. Yes, thank you for the question. No, the apartment was not initially bought, and there was no agreement like that, because my mother saw the pressure that I was subject to in Cherkasy District Administrative Court. And in order to avoid some manipulations and in order to preserve my nervous system and accommodation, because she told me that I could lose this accommodation, she decided to register that in her name, and I did not object against that. She was afraid of these risks. So she said, if we register that in, well, morally, I have no right to take away my mother's funds. I'm an adult. Why should I take my mother's money? And even if we shared the expenses on this apartment, I still respect my mother, because my mother is a saint for me. She is a great authority for me, and her opinion is always wise. She has always supported me.
Okay, let's get closer to the point, Madam Tamara. In your explanations, you have mentioned 280,000. That these are the funds of your mother. So, with all due respect, and unfortunately, teachers they have no chance or opportunity to make so much money. In your written explanations, you spoke about the following, saying that 200,000 that was paid by your mother. That's from the sale of the privatized land plot in the Kiev city, in the Kiev village, village of Semipolki. Tell me, please, why can't you have the confirmation of this? I cannot confirm it with the documents. I still don't know how much, what was the price when she was selling it. I even asked her yesterday. She's always gets upset with me when I ask her. Because she said that I have suffered a lot because of your profession, and why my life, her life, why the state is looking up into her wallet. So if my mother was in relations with my father and he gave her some money, and I don't know which money or how much, and so she used them as the way she thought she wanted to use them. So why should I investigate this and ask her, Mom, where did you take money for this? I see. If you need an explanation, I can ask her to write the explanation. We have requested these explanations for 3 rounds. I'm sorry, but she said no. Okay, I understand. Thank you. In your documents and the explanations, you mentioned that you rent this apartment. I think you, as a lawyer, probably understand the difference between using and renting. Do you confirm that you rented from your mother, or do you pay the rent fee? Thank you for your question. I'm so sorry. I would like to clarify. Maybe I mentioned this in the explanations, but in the declaration it says use. It says other use. I'm so sorry. That's why we hold this interview, to get answers to all the questions. Okay, thank you. Tell me, please. Since you prepared the explanation, you said that this is the apartment in the new building. So, what was the money to be used for the refurbishing, repairs, and the rest? The public and the advisory group of experts always has the impression that all judges are the same and they all live in a very good life conditions. But currently, the repairs haven't been completed, unfortunately. I only have the floor, the walls, and I haven't even managed to have electricity there. I don't even have money to buy the lamp. So how are you using it? Well, it's difficult. I don't want to say it in broadcast live. I don't want my competitors or enemies to be happy about this. Okay, we heard your answer. Madam Hanna, please.
And in your, because now we would like something more on your asset declaration. In your 2015 and 16 declarations, you indicated that your actual place of residence is Cherkasy. Additionally, in a written response to our group, you explained that you have been living in Cherkasy since 2007. However, in your 2015 and 2016 declarations, you did not declare any real estate object in Cherkasy where you could reside, despite stating in your response to the group that you were renting accommodation. It was probably a follow-up to the question which was done by Oksana, because everything is very clear. And then maybe I would add also my next question, because you also have a room in the dormitory in Kiev. Why did you not declare the right to use the room in the dormitory in Kiev at the address where you are registered in your 2015-2017 declarations? It's everything concerns the declarations between 2015 and 2017. And why you reside in the dormitory in Kiev, why living in Cherkasy, what was the reason to have such a dormitory in Kiev? Okay.
I understand. Okay, thank you. Thank you, dear advisory group of experts. The question is really confusing because it is something that is directly connected with my professional activity. Since in the position of the judge, I have been renting accommodation all the time as of 2007 because I had nowhere to live, because I couldn't travel 300 kilometers here and there because it's physically impossible and I do not have the car. Second, all accommodation that I rent at that time, it was very cheap because I couldn't afford to have some expensive accommodation. So because I had my daughter was a student, and it took half of my salary for her studies, for her education, and the rest of the money was for food, and I had no other money. That's why I had to rent a very shabby accommodation, because it had to be something for food and something for accommodation. So people who were renting this apartment to me, they did not always behave well. And one of the examples, when I came to my room, for example, I had to always smile even when you're in a bad mood. If you don't smile, they can kick you out and they will take somebody else. So often I had to change, and those tenants who rented the apartment for me, they did not conclude an agreement. So I couldn't register it, or because they didn't want to pay taxes, and the situation there was very challenging. And back then I couldn't even think about buying or purchasing the accommodation. This was something out of proportion. But later on, when they didn't recommend me for the position of the judge in 2012, my powers were by decree of the President Mr. Yanukovych, I was dismissed from my position. And while this situation was indefinite, so I couldn't work as an entrepreneur or lawyer because I was dismissed from the position of the judge. But I was in the situation that I could renew. So because there were some court hearings, so I arrived to Chabane. Since there was half of the apartment given by my father. That's why I lived there. And for 1 year, I didn't work at all because I had no salary. Because Kovalenko, who was the chair of the court back then, he gave such a certificate that I couldn't even go to the employment center. And only 6 months later, maybe even more, as of September the 1st, 2014, I went to work to the higher educational establishment of Kyiv. and the position was the associate professor, and later on I was the deputy department. And so the director of the Institute of Law, the Regional Academy of Human Resources Management, they just told me that Tamara Andreevna, it's difficult for you to make this trip, so I will write you a recommendation so that they would give you at least a room in the dormitory. So this was a gesture of goodwill, and they gave me this request, which served as the grounds for me to be registered in the city of Kyiv. But I was hoping that it was going to extend my powers, or at least I would work at the university in that position to continue the scientific work. But 1 year later, I was renewed in my position and I returned to Cherkasy. That's why I did not finish the procedure for obtaining the room in city of Kyiv at the place of registration, and it's not completed up until now. That's why I do not have a room. I have added to the explanations the information, the document actually that I have requested as of 2019-2021 to give me the room in the dormitory. I got denials, rejection, and I even referred to the city mayor, but they rejected. But they were writing this rejection thinking that the Cherkasy district court will give me the certificate stating that I will work in Kyiv, and only then they would provide me with accommodation. So it was a very complex situation. That's why up until now I'm without accommodation. In Chabany, I live in my father's apartment. As for the property that you asked me why I didn't register it, because back then the owners of the property, they didn't give the possibility to make the agreement so that I could register it, and I changed it very often, like every 1 month or every 6 weeks I would have to change it because it was very uncomfortable. Can I clarify the question? So you are in the position of the judge in the Cherkasy district court. Do you get the salary? Currently, yes. As of which moment have you started getting the salary? So in 2012 you didn't. Then when did you start getting your salary? When I entered the position, as of July 2015. July 2015. Up until now, you are getting the salary of the judge that is equivalent to the salary of the district court. A clarification. It is a bit smaller because without powers, yes, but I obtained salary and it is reflected in the declaration. So having this salary, you work in the interregional academy. No, not now, but you used to, right? You used to. You did work then. I worked as of September the 1st, 2014 until June the 5th, 2015. So as of 2015, you was registered in this room in the dormitory. No, I do not have the room. That procedure was not completed. They did not sign the agreement with me. They only registered me in the building. The room hasn't been even specified, so only the dormitory. I only am assigned to this dormitory because the procedure wasn't completed. But okay, since as of 2017 you have the apartment in Cherkasy and you live in Chabany, have you then finished that procedure, or you still say that you need that room in the dormitory? No, I'm not raising this question anymore. It has been left unresolved because I don't know anymore how the situation will go. It's unclear, but I do not have that room. That's why I want to draw the attention of the advisory group that in the explanations for 2015 there was no such thing as specifying the room in the dormitory, because there was no such explanation. If you are registered and you do not have accommodation, you do not have to enter this data, but later after 2017 then this was explained. But so much time has passed since 2017 and you still haven't completed the procedure. Okay, thank you. Ms. Tamara, you're saying, and I go through all your property rights, that you plan to stay in Cherkasy, correct? No, I do not plan. Then how can you explain that if you do not plan, in 2021 you are privatizing the land plot in Stepankivska village council on approval of the project for the land plot to Tamara Novikova? Thank you for your question about the land plot. So there is the law and the right of the citizen. Me, as a regular citizen, I submitted the application to the village head who has these land plots. He told me, we can give you in the forest. Okay, we know where it is located. It's not far away from Cherkasy. I wouldn't call it the forest. I don't know what the forest for you or the woods. But tell me, please, how did you learn about the available land plots? But each citizen has this right. Yeah, but why there? Why not far from Cherkasy? It's not the worst possible option, by the way, near Cherkasy, the village Khatske. Moreover, do you belong to the Stepankivska territorial community? No, let me explain. The thing is, I did not want to live in Khatske. It's a village, and they refer to Stepankivska territorial community. I did not want to be there because it's 25 kilometers away and there is no road there. So I'm saying this is inconvenient. I wanted to have closer or nearby, but just because there was nothing available in other regions nearby, so I requested the available ones, and that was the only one available. That's why I purchased it. And what was the aim of you using your right for the free land plot? Well, for construction, but I'm not going to do the construction there because I have no money to do that. I was counting on having a good land plot so that I could have a garden there. But since I'm not going to do this, is not relevant currently because it's more losses there than profit. Okay, if you check on the map, you can see where it is located, and even the experts who came there to assess it, and they said, Tamara, it will be more costly for you, but you still made that decision and you purchased it. Not purchased, but you got it. Another question, which is also very important for this competition, it's about your motivation. Tell me, please. Of course, we collect information. And did you participate at the competition for the heads of the local administrations in Mykolaiv and Vinnytsia region? I would like to remind you and to remind all those who are listening to us that you have participated in the competition for the director of the National Anti-Corruption Bureau, as I said, of the heads of the local administration, both of Mykolaiv and Vinnytsia region, the judge of the highest court of the intellectual property, anti-corruption court, the cassation administrative court in the Supreme Court, also the member of the High Qualification Commission, and also the previous competitions for the Constitutional Court of Ukraine. And currently, you're also participating in 3 competitions: our competition for the judge of the Constitutional Court of Ukraine, the position of the High Anti-Corruption Court, and 3rd competition for the position of the Courts of Appeal position. So tell me, please, what is your motivation to participate in all competitions that are held in the state of Ukraine? Thank you so much for your question. Well, first of all, I'm just an active person. In my life, I always try to develop, and even if it's hard, even if whatever, I just try to move on, to move forwards. Why I in 2015, after dismissal, went there? Because I wanted to get some use of my knowledge and skills. I wanted to be useful and to have some tangible positive results, but not to just do whatever, like any job, just to say that I work. I never agree to such options. That's why I participated. And from the point of view of one more circumstance, I have defended the thesis. I have the degree of the candidate of the legal sciences. By the way, they didn't recommend me for the position of the judge because the head of the court didn't give me the characteristic. Let's not speak about the head of the court. Yes, but this was a very painful matter for me. It still is. And no, you're moving away from the question. We are not asking or questioning your thesis or scientific degree. That's good that you have the opportunity to implement your scientific potential. But another thing that it's a different, these are different spheres of competitions. These are different spheres of activity without even mentioning the head of the administration in Vinnytsia and Mykolaiv oblasts. Because do you know Mykolaiv and Vinnytsia oblast very well? Do you know the life of their community? So the question is, why do you have such a, different, various interests? So, dear experts, I have 3 higher educations. One of them is managerial. I'm the master of the state governance. I have undergone some trainings in Poland, and the topic was the administrative reform in Poland and Ukraine. I have the developments. I used to be the head of the department. I used to work on the local self-governing, and I specified which questions I considered. I'm curious. I love this subject matter, and I thought that if I have this education, why not to, try this managerial sphere as well as I have this education. Since my thesis was also on the administrative provision, and these topics are interrelated, and currently the matrix of responsibility in the judicial system is interrelated with this responsibility that is cross-sectional in all these competitions that is done by any competition commission or selection commission. So thank you so much. I have never visited any competition of this high level before.
In your opinion, what prevented you from success in all of these competitions? First of all, certainty. Your? No. Not my certainty. Back then, when I was participating in the competition for the competition of the director of the NABU, I did not have enough points because it was 2015. I did not get enough points. That's my sincere answer. With respect to the head of Mykolaiv state administration, there was another candidate who was more comfortable for the nominating entities, so I realized that I would not get success there. With respect to Vinnytsia, my mother is from Vinnytsia, so that's the very dear and near region for me. So that's why saying that I cannot implement that. No. We are just saying that you have the right to do that. We are interested about your motivation. My motivation is I want to explore myself in all the directions. Then all of this will be accumulated, and I've shared the link to my most recent publication with respect to all of these competitive selections. Thank you, Tamara. Then let's discuss your motivation letter for this competition. In particular, we have your motivation letter in front of us, and it's focused on the fact that your decision to participate in the competition for the position of the judge of the Constitutional Court is related to your huge desire to contribute to the work in the new format of the judiciary. The key directions, in your opinion, include priority directions like restoring trust in the judiciary, transparency of the court process, etc. How is the Constitutional Court corresponding to the judiciary? Yes, thank you so much for your question. The matter is that the decisive factor in this position that I've presented, let's go back to my activities. I was the head of the department of the Fund on Self-Governance. May I ask one question? Do you think that the Constitutional Court is a part of the judiciary? No. But in your motivation letter is about the judiciary. May I finish my opinion, please? I was present several times at court hearings of the Constitutional Court regarding self-governance, and I saw that the Constitutional Court has the perspective to reform this judiciary institution which could be closer to people, which could be closer to all issues regarding protection of human rights through the constitutional complaint. Back then, the situation was developing. Back then, it was 2001. It was very interesting because the issue which were the subject matter during the hearing where I was present did not cover citizens as members of the territorial community. I'm asking you about the judiciary. Why do you correspond your motivation to become a member of the Constitutional Court exclusively with respect to the judiciary reform? How can the Constitutional Court be involved into the judiciary reform? That's my question. Yes, thank you for your question, but the matter is that without the Constitutional Court, the judiciary reform will not be complete. Can you please explain that in more detail? Because after all national courts, after all levels, after all instances, we go to the Constitutional Court. If the law does not regulate issues initiated during consideration concerning protection of the rights. And with respect to the judiciary proceedings, with respect to pension-related issues, so etc., through the development of the constitutional jurisdiction within the framework of the reform, it had its objective and broader vision for citizens, because the entire judiciary is aimed at serving citizens, the people of Ukraine, and not being distant from the people of Ukraine. It has to protect their rights and not just to be the institution. So I wanted to compare elements which exist abroad, that is foreign experience. Can you please explain? Your active position is really interesting. Foreign experience. What would you like to involve from the foreign experience? First of all, interpretation of the law in the US. Yes, I understand. There it is done by the Supreme Court. There it is done at the level of the Supreme Court or at the level of courts which consider the case. They have these authorities. Maybe I'm wrong, I'm sorry, but back there the situation is different. So I would like to borrow their experience in order to bring the constitutional jurisdiction closer to Ukrainian people. Thank you, Tamara. I have no other questions. Let me ask a question. My first question is that we've noticed some contradictions, inconsistencies between your written answers in response to the AGE's questions and the oral answers that you are providing today. The first one is about the place of residence. In your written explanations, you informed that since 2017, you've resided in Cherkasy. Today, you said that actually you live in Chabane. So, where do you live? And what is the reason for these contradictions in your explanations? Thank you so much, but if I've worked since 2015 in Cherkasy, so I reside there. But if we are talking about my initial appointment, that was 2007. Okay, so where have you resided since 2017? In Cherkasy. So what is the reason for these contradictions in your explanations? Today you said that you live in Chabane. No, I meant that nowadays I've come here from Chabane. Okay.
With your mother, now I heard that you are living with your father. And when are you living with your father? Yes, it was true or not? Because I write even so. Yes, where are you? Are you coming from? Exactly now, exactly. Kiev, Chabane, Cherkasy, I don't know where.
Thank you so much. The matter is that my father gifted the apartment to me. He used to live in Chabane. He is dead now. He lived in Chabane. Half of the apartment was gifted to me in 1997, and the other half was gifted in 2013 to my daughter. But in 2003, I registered my mother there because she came from robbery there, and I could not abandon my mother in the streets. So she sold her house and she bought a separate apartment, but that's another story. However, with respect to my place of residence, since 1997, when my father gifted the apartment when I was registered there in 1998, and until 2007 or even 2008, because I was appointed to the position of the judge back then, I lived in Chabani. Since 2007 until 2013, I lived in Cherkasy. From 2015 and until nowadays, I have also lived in Cherkasy, but I come here from Chabani because I have to spend the night somewhere. With respect to the apartment in Cherkasy, that has attracted attention of the AG, the method this apartment was bought, and you've explained that funds used to buy this apartment have been received from the sale of the land plot. The land plot was sold by your mother. Today, in your explanations, you said that your mother was crying that she did not like that the state tried to look into her wallet and that she did not provide this information to you. But in your written explanations, in response to the same question of the AGE, you informed the AGE that the price of that land plot amounted to 200,000 hryvnias. So that was the amount your mother received from the sale of the land plot. So, what is the reason for your contradictions in your explanations? Are you aware of this amount, and what was the amount? Yes, thank you for your question. It's very relevant, in fact, but I would like to say that my mother had her own savings, and I did not know that she had this 200,000 hryvnias. Maybe my father gave some money to her because my father died in 2014. No, you state that that is the amount that she received from the sale of the land plot, or was it some other amount? No, I've explained that she had savings, and there you had the list. You said savings in the amount of 80,000 hryvnias and 200,000 hryvnias from the sale of the land plot. So that's the reason for my question. What is the reason for the contradictions in your explanations? 50,000 were from the sale of my land plot, but I don't know what was the price of sale of my mother's land plot. That's some new information that we did not have. Did you have some other land plot? No, there you had that in answers to the questions, and several times I've provided this answer. That was as of June 21 and as of July 1. No, there you stated 80,000 as savings of your mother plus 200,000 hryvnias from the sale of the land plot in Kiev region. She sold the house and 2 land plots. There was a big house. Let me ask one more question, please. You participate in many competitions for different positions. Yes. I would like to draw your attention to the fact that now another competition is ongoing, also for the position of the Constitutional Court of Ukraine, but under the quota of the Congress of Judges of Ukraine. So I have a question. Why you, as a professional judge, have decided not to be nominated by the judicial community where people know you, but you've applied for the competition under the president's quota? The president of Ukraine is a political figure, and probably, while taking the decision regarding appointment of the judge of the Constitutional Court, among other things, he will be also governed by political considerations. But you are outside of politics. You are a professional judge, and you should be politically neutral. Can you please explain your choice? Why, when we have 2 competitions for the same position in the Constitutional Court under the quota of the President and under the quota of the Congress of Judges, why have you decided to run from the President? Thank you for your question. The matter is that my previous participation under the quota of the Congress of Judges, I did not get enough votes. So the situation was the following, that people like different people. But this time, I have the very limited time As you've probably correctly pointed out, I participate in all the competitions, and I have very limited time, so I've applied for the first announced competition for the position of the judge of the Constitutional Court. For me, that was not a decisive factor, whether it would be under the quota of the president, or under the quota of the parliament, or under the quota of the Congress of Judges. A judge of the Constitutional Court should be independent regardless of the quota. It does not matter what quota that is. So it will not prevent me from being neutral while taking decisions. Okay, I understand your question. Thank you. Do we have any other questions to the candidate, Novikova, from other members of the AGE?
Madam Novikova, I would like to come back to the initial question, which refers to the decisions of the High Qualification Commission. In your answer, you mentioned the decision from the year 2018, negative decision. And you mentioned that in that decision, the High Qualification Commission said that they consider you as a corrupt person. Can you explain more in detail these circumstances? Why they consider the corrupt activity? What kind of activity was this? And do you consider this as a correct assessment of your integrity? And if not, why not? Thank you.
Thank you so much for your question. That's a very relevant question. I was very interested in that as well. I would like to talk with members of the HQCJ, but I did not have the chance to do that because they did not appear at the court hearing. But I would like to add to my explanations that as compared, when we compare the decision as of 2016 of the HQCJ with one composition, and when we compare this decision with the decision of the HQCJ in other composition, the same issues were assessed in different ways. In 2016, it was stated that that there were no concerns regarding anti-corruption issues, and the HQCJ was satisfied with that, and I got respective scores. In 2018, again, being admitted to the second stage, during the interview, the HQCJ recognized that there were signs of the lack of integrity, but they were not reasoned, they were not justified. And the HCJ denied in dismissal because there was no motivation. And why there was no motivation? Dear members of the AGE, there was no motivation because I failed to pass the qualification evaluation in 2018 because I got zeros for half of indicators. My assessment was not complete, and there was no definition, no determination. They just quickly took that decision, and they submitted a recommendation regarding my dismissal. Of course, as an ordinary citizen, I had doubts why I had zeros with respect to half of indicators, why I was admitted to the interview, while all cognitive testings which I passed, I had the highest scores. I've provided as an attachment those documents if you are interested in that. I had the highest scores. I got the highest score for the testing. Without having received zeros, I submitted a claim to the court, but the court does not have the authority to interfere with discretionary functions of the HQCJ, so it was left without consideration. It's not that they revised, but it was not their authority. And now we come back to the decision of the HCJ, which considered this issue and decided that it was not motivated because half of indicators were absent from evaluation, and so that's why they believed that it was necessary to refer Judge Novikova to the HQCJ for the resolution of this issue, for determination of the stage where Judge Tamara should undergo evaluation. And since June 12th, there was taken a decision that I have to undergo qualification evaluation for the first time, again testings, again interviews, but I'm not afraid. I will undergo this evaluation as many times as the state of Ukraine requires, regardless of whether it is necessary to do that 10 times or 20 times. I will do that every year. I want to prove to the society that I have integrity and that there should be no doubts about my integrity. Thank you very much.
I didn't get any concrete answer on my question, but thank you anyway. So I have no further question.
Do we have any other questions? If there are no questions, Tamara, now, as we've informed you at the very beginning, now you have the opportunity to address the AGE with your concluding remarks. And please do that within 5 minutes. Okay, thank you so much for the given opportunity. Dear members of the advisory group of experts, this competition is the highest, unprecedented, most honorable and most objective competition. That's why I've decided to participate in this competition in order to resolve all the issues so that the society would understand whether the candidate is worthy of this high position. Well, maybe there are some doubts that should be refuted, or maybe I should provide some evidence to refute those doubts. So, of course, I could refrain from participation in the competition. Other judges do not do that, but I have this extreme necessity in order to resolve all the issues. So I'm really grateful for this opportunity. Thank you for listening to me. Thank you for studying all of my materials. Thank you for studying all the evidence that I've provided. Thank you for asking questions, and thank you for inviting me to this interview. For me, this is a huge honor to be present here today at this interview, and let me again to express my gratitude to you and wish you all the best in your work. I wish you to choose the best candidate who will get this high position. In turn, I would like again to tell you that I'm really grateful, and I will hope that Ukraine will win after all in the fight against corruption and in the East against armed aggression. Thank you. Thank you, Ms. Tatiana. Thank you for your participation in this competition. Thank you for answers to the questions that we've had to you. And now the interview of the AG with candidate for the position of the judge of the Constitutional Court of Ukraine, Novikova Tamara Vadimevna, is announced as complete. Thank you.